Thank you for joining us. The following presentation is from a webinar titled A Practical View of Obamacare, originally produced on April 25th, 2013. The presenters are Suzanne Sentman with McKonly Asbury and Micah Saul with Devine Law Offices. Enjoy the presentation and be sure to visit us online at www.macpas.com for future events and webinars.
Thank you, Reed. One of our goals here at McKonly and Asbury is to provide timely information and guidance to our clients. Given the complexities of the upcoming Obamacare, if you will, we have with us today Micah Saul from the Devine Law Offices in Lancaster to provide us with some updated information. As many of you know, healthcare reform is very complex with many moving parts and many changes occurring, it seems, weekly. Micah Saul is an attorney with the Devine Law Offices where he practices employment and business law, representing and advising employers in a wide range of legal matters. He is a cum laude graduate of the University of Pittsburgh, where he obtained a Bachelor of Science degree in psychology and is a graduate from Widener University School of Law. Micah is a member of the Pennsylvania and Lancaster County Bar Associations. Also, he provides this information to many of the clients at Devine Law Firm on a routine basis. Micah, would you like to talk at all about the Devine Law Firm?
Absolutely, and thank you, Suzanne. And first of all, thank you to McKonly and Asbury for having us in. We appreciate the opportunity to speak with your clients about this really hot topic. At Devine Law Offices, we offer a full range of employment law services, from basic counseling and advising with respect to employment policies, handbook reviews, and trainings, things of that nature, all the way up to defending discrimination claims, workers' compensation claims, and unemployment compensation. And as Suzanne indicated, healthcare reform is definitely a hot topic at this point in time. Obviously, there are a lot of moving parts. Recent challenges to the law have actually failed. As we all know, back in 2012, in July, the Supreme Court upheld the law as constitutional. And our last hope for overturning Obamacare was the elections in November, which pretty much ensured that there will be no major changes to healthcare reform coming up in the near future. So as a result of that, the time to prepare is now, and that is one of the purposes that we hope to accomplish with our webinar here today. We are going to discuss the requirements that the law has put into place for 2013, and we will also provide you with 5 questions that you should be asking of your company to determine your position for compliance in 2014 when other major provisions take effect. As an overview, for 2013, some of the new provisions that we're going to be faced with will be the W-2 reporting requirement in relation to employee cost of health insurance benefits, the provision of notices of state exchanges. The IRS has also placed a cap on the annual salary reduction from flexible spending accounts. And finally, we will also be required to issue what are called summaries of benefits and coverage at certain intervals beginning in 2013 and beyond.
And Micah, I just wanted to ask you this, just because I know that the folks listening out there today could be of various sizes and, occupy different locations throughout the area. So would this W-2 reporting apply necessarily to a certain sized employer, or how can you maybe address that now? And sorry, I don't mean to load up questions here too, or comments, but also I just wanted to remind the listeners out there, we mentioned that we will be answering questions as they come through, or you may hold them till the end of the presentation. So just a reminder to everyone out there.
Sure, and to answer Suzanne's question, the various provisions of the healthcare reform law apply differently to different sized employers. We will be getting into the employer sizes and how it affects various provisions of the law throughout the presentation. So just stay tuned, and each provision we will provide the clear thresholds in terms of employer size if they are given in the law. So moving forward with 2014, that is when the large employer mandate will take effect, and that is sort of the doomsday year that everyone is anticipating. That's when employers will be required to offer full-time employees health insurance coverage. There are requirements on the type of coverage that must be offered, and we also will be looking at penalties for failure to comply with the law if you are subject to it. So as we alluded to earlier, in 2013, we are going to be faced with the W-2 reporting cost of coverage requirement. That specific requirement should have already been satisfied by any employer who issues more than 250 W-2s in a given calendar year. As you can see on the slides here, you must report both the employer and the employee cost of coverage on the W-2. You do not have to report dependent coverage costs to your employees. The types of coverage that you are required to report the costs of include major medical, flexible spending account coverages or contributions, employee assistant programs, on-site clinics, wellness programs that provide medical care, and hospital indemnity or specified illness plans. The next requirement that will be taking effect in 2013 is the issuance of notices of exchange. Initially, this requirement was set to take effect on March 1st, 2013, but because the federal government has had some substantial issues in setting up state exchanges, the requirement has been pushed back. The guidance that we have seen suggests that the notice will be required to go out sometime in August of this year. The notice must contain certain information under the law in order to be compliant. It has to describe what the state exchange does. Basically, the state exchange is a marketplace whereby individuals can go and purchase health insurance benefits on a package-by-package level. The notice also has to advise employees of their potential eligibility for tax credits to purchase coverage through the exchange, and we also have to notify our employees that they are likely to lose our contribution toward their health insurance coverage should they decide to purchase through the state exchange. As we indicated earlier, the next big change that is in line for 2013 and actually has already taken effect is that there is now a $2,500 cap on employee pre-tax flexible spending account contributions. This is only applicable to flexible spending accounts, health savings accounts, HRAs, Archer MSAs. Those are not included. So this $2,500 limit is again annual, and it is a per employee limit. And the final requirement that has gone into effect this year is the provisions relating to the issuance of summaries of benefits and coverage. Basically what those are health insurance documents which provide a brief and clear description of the benefits provided under the health plan. They inform the employees as to how much the plan covers in terms of costs for medical care. And they also provide information, contact information to the employees should they have any questions or concerns regarding their coverage. These forms must be provided at 3 different intervals. The first is open enrollment. The next is if you get a new employee after your open enrollment, you have to provide them with the SBC at initial enrollment. And then we also have to provide the SBC within 7 business days of an employee's request. Now, one question that we have commonly fielded in this regard is who issues the SBC? And the answer to that question depends on whether your plan is fully insured or you're self-funded. If you're fully insured, your health insurance carrier will be issuing the SBC. If you are self-funded, you should contact your third-party administrator if you have one, because it will be either your third-party administrator or you as the plan sponsor that's required to issue the SBC. So now we are going to move on to 2014, which is, as we alluded to earlier a bit, the doomsday scenario that all employees are sort of worried about here. This is when our responsibility as employers really kicks in. So we can see the shared responsibility provisions are applicable only to large employers. We must offer health insurance to our full-time employees and their dependents. Definition of dependents has been expanded to include children up to age 26. However, we've left out spouses now. Spouses are not considered your dependents. The coverage that we offer has to be affordable and of minimum value. The coverage must be minimum essential coverage. And then, of course, the hot topic, the penalties for failure to comply do take effect in 2000.
And Micah, I noticed on that slide you have many of those terms, such as large employer, in quotes. Does that suggest there's maybe some ambiguity with the current law or the way the law is being interpreted?
Well, that's a great question, Suzanne. Healthcare reform has basically created an entire new language with respect to benefits, with respect to employment law, and we do have specific definitions for terms such as large employer, minimum essential coverage, minimum value, and we will get to those later on in the slideshow on a point-by-point basis to try to break it down and make it into more digestible pieces. So the first question that you're going to want to ask is our company subject to the large employer mandate? And in order to answer that question, we have to know what constitutes a large employer. The healthcare reform law has defined a large employer as one who employs at least 50 full-time employees on business days during a given calendar year. A full-time employee is now considered to be one who works or performs at least 30 hours of service per week. So that might be a bit of a deviation from your standard practices. I know traditionally we've considered full-time to be 40 hours. Well, for the purposes of healthcare reform, we have to forget that definition. And we've got to understand that a full-time employee now is one who averages 30 hours of service per week. The other odd facet in determining whether or not you're a large employer is that you have to consider your part-time employees into what are known as full-time equivalents. And the way that we do that is we will add up all of the hours worked by our part-time employees, and we'll divide that number by 120 every month. And the result of that calculation is our full-time equivalent. So, for example, if our part-time employees work 120 hours and we divide that by 120, we get 1. So we have 1 full-time equivalent. If we employ 49 folks who work 30 hours per week or more, and we've got 1 full-time equivalent, now we're a large employer and we have to offer coverage to our full-time employees. The other thing that we need to be concerned with under our definition of large employer is if we have multiple companies that are operated under common control, those will be considered to be one large employer for the purpose of the healthcare reform law. And what we mean by common control is that the same 5 or fewer officers or shareholders own 80% of both companies. Other elements include if we offer the same group health plan between employees of both companies. Do we have a common handbook? Things of that nature are all factors that will go into determining whether we are operating our companies under common control, which could push us up over the large employer threshold. There is an exception. Some employees don't necessarily need to be considered in your calculation for how many full-time employees you have, and that would be for seasonal employees. Seasonal employees are those who, by the very nature of their work, cannot perform the task year-round. So, for example, here in Pennsylvania, an amusement park might have 60 full-time employees during the off-season, and then they could balloon up to 175 employees during the high season. Those extra workers that come in during the summertime obviously can't perform their job duties over the winter here in central Pennsylvania because we're not going to be operating our roller coasters in 6 inches of snow. So those are seasonal workers, and they don't necessarily need to be factored into our calculation in determining whether we're a large employer.
And Micah, that just makes me think of a question here for the listening audience. But which employees would be entitled to participate in the group health plan, or how is that defined? Can you talk about that a little bit?
Absolutely, and that is a great question, and it is the second question that you should be asking yourself as an employer to determine your status for compliance in 2014. Employees who are entitled to an offer of coverage from their large employer are those who are considered full-time. As we discussed a little earlier, healthcare reform has created an entire new language for us to understand. So we'll get into the definition of full-time employee in just a minute. Some other offer of coverage limitations that are imposed by healthcare reform include a limitation on waiting periods. Your waiting periods cannot exceed 90 days now. So we have to be very careful with our language in our handbook that says the employee is eligible to participate in the group health plan on the first of the month following their 90-day anniversary. That's going to violate the law. The other thing that we have to be concerned with is offering different plans or better plans or quicker availability of coverage to our highly compensated employees. Very quickly, highly compensated employees are those who are your 5 highest paid officers, holders of more than 10% of your company's stock, or your highest paid 25% employees. So every company does have highly compensated employees, despite what they might say to you during their annual review.
And Micah, if you could speak to, under that first headline there, the full-time employees must be offered coverage, where it talks about no requirement to offer coverage to part-time employees. Is it true that perhaps maybe employers who are generous with their benefits and perhaps offer insurance to those part-time employees could be now kind of held to that standard, whereas if they didn't offer the coverage, they might not necessarily be on the radar, so to speak?
Sure, and that's a great question, Suzanne. The answer under the healthcare reform law is simply no. They're not going to be held to that higher standard. They can, not offer their part-time employees coverage if they so choose. But the danger in doing that is, we can't just look at healthcare reform in a bubble. We have to understand that our decisions that we make to comply with healthcare reform can also affect our company in terms of employee relations, public perception. So if you would pull your insurance from your part-time employees, I imagine that you will have several disgruntled employees, and that is something that certainly would need to be taken into consideration before you make that decision. But will you be penalized under healthcare reform for doing that? Absolutely not.
Okay. Thanks for clarifying that.
Absolutely. So back to our definition of full-time employees. Obviously, as we discussed earlier, that is one of our new terms under healthcare reform, and that has been defined as any employee who provides an average of 30 hours of service per week. Notice that we're not saying 30 hours worked, we're saying 30 hours of service. And that is because a recent proposed rule by the IRS suggests that hours of service will include any time to which the employee is entitled to compensation. So if they take a paid vacation, that is going to go toward their hours of service in terms of determining whether they work 30 hours or perform 30 hours of service per week. Now, employees who are clearly full-time under this definition must be offered the opportunity to participate in a large employer's group health plan. But part-time employees, variable hour employees, those whose full-time status can't easily be determined, present a unique problem to which the IRS has provided a solution, albeit a confusing one.
And Micah, just a quick question. Are there any tools out there that you can recommend maybe for ease of calculation in determining your full-time employees or equivalents?
Sure. There are various time tracking programs already in use by many employers. For example, Kronos is one that I can think of off the top of my head, where your employees are entering their hours in order to get their paycheck. And what we know some employers are doing is they're simply generating reports on an employee-by-employee basis to get those hard numbers right out of their system. I also know that some health insurance providers are coming up with calculators and various different little tools that they're providing to their clients and customers to use in order to ease the burden of the calculations that we're just about to discuss here.
Right. So could the folks that are listening today, maybe they could push back to either their insurance carrier if they're fully insured or their third-party administrator, maybe in just helping with those calculations. For example, I know for us, we're fully insured, and our insurance provider has, pushed over to myself just some quick, methods of calculating that number.
Yeah, absolutely. And that also raises another point that's important to keep in mind for the folks listening today is that you don't have to go through this alone. This should be a team approach. You should be actively involved with your health insurance carrier or your third-party administrator in formulating your strategy for compliance with healthcare reform. And to the extent that you do have some issues, you should also not hesitate to contact legal counsel to address those issues before the federal government uncovers them and we're dealing with another situation altogether.
Good advice.
Now, to determine the status of one of those employees who works variable hours and thus determine whether or not they're entitled to an offer of coverage or an offer of participation in our group health plan, the IRS has recommended that for ongoing employees, the first step that we take is to establish what's known as a standard measurement period. The standard measurement period basically is a predetermined number of past months, anywhere from 3 to 12 months long in duration. And the standard measurement period must apply uniformly to all employees in the same employment classification. The IRS has allowed for 4 separate classifications, those being collectively bargained versus non-collectively bargained employees, your salaried employees versus your hourly employees, employees of different business entities if your company has several subsidiaries or sister companies, and also employees located in different states are allowed to be subject to different measurement periods. So once you establish that measurement period, what you'll do is you will go back and determine and perform your calculations to see whether a given employee has averaged 30 hours of service during the measurement period. If they have to be offered the opportunity to participate in your health insurance plan for what is called a stability period. The stability period is a period of time ranging from 6 to 12 months. And this period is when the employee who has qualified for coverage under the measurement period calculation must be allowed to participate in the plan. Now, if an employee is determined to have met that threshold, they must be able to participate in the plan for as long as your measurement period. If they have not qualified for coverage under your measurement period, then you have to recalculate again in a period that is no longer in duration than your initial measurement period. So we understand that what I just spoke about is pretty confusing. So the best way to work through this is by example. So let's say that we have a company, Big Corp. They set the following measurement and stability periods for their ongoing employees. The standard measurement period runs from November 1st through October 31st. They have a stability period that runs from January 1st to December 31st, and they've got an administrative period where they can calculate the employees' hours of service and enroll them in the group health coverage of that period is 2 months. So in year one, we have employee John, who works for Big Corp, and he averages 30 hours a week from November 1st through October 1st, 2013. Big Corp has to offer John coverage from January 1st, 2014 through December 31st, 2014. Now in year two, John continues to work for Big Corp, and this time he averages less than 30 hours of service per week from November 1st, 2013 up through October 31st, 2014. John's coverage has to continue through December 31st, 2014, but Big Corp does not have to offer John coverage beginning in January 1st, 2015 because he failed to qualify under the measurement period calculation in year two.
Wow, Micah, that is a lot of information to try to wrap one's head around. I guess just right off the cuff, how do folks know maybe when to set those measurement periods?
Sure, and that is a question that we get quite frequently. And the best practice in setting your measurement period is to have a legitimate business purpose in mind when you're doing it. For instance, if you are a construction company and you have a downtime through October that runs up until March of the following year, you don't want to set your measurement period there, because if you're audited by the government for compliance with healthcare reform, they're going to look at your measurement period and they're going to say, why did you set it at this time span? And if your answer to that is, well, because our guys don't do as much work during that time, you can expect to be looking at some sort of penalty or fine because you're trying to subvert healthcare reform. So always keep in mind that you need a legitimate business reason to set your measurement periods.
And with that, what about trying to sync up with, your open enrollment period? For example, we are not on a calendar year. Ours straddles October through the end of September, and recognizing we're always trying to shop competitively, and there's always that possibility of switching carriers or just looking at different plan designs even. So any recommendation there with kind of getting things to sync up with the enrollment period?
Sure, that's a great question, and not only is it a great question, but it also serves to answer the prior question. Setting up your measurement periods to sync with your open enrollment is a legitimate business reason. It reduces the administrative burden on you and your company and the human resources department from having to have effectively several enrollment periods throughout the year based on our variable hour employee calculations. We can just get it all handled at one time during open enrollment. That's certainly a legitimate business practice.
Thanks.
The IRS has also established a method to calculate new employees' hours of service if we're not sure whether they're going to end up averaging 30 hours per week. Now, again, as we noted before, any employee who is clearly expected to average 30 hours or more per week must be offered coverage. You've got to enroll them in your group health plan within 90 days of hiring them. But if you hire somebody on a variable hour basis, maybe they're going to work for you on an assignment by assignment contingency, and they're busy sometimes, and other times they're less busy. We have to run them through the initial measurement period calculation if they are a new employee. And the way that calculation works is that you will select a predetermined number of months from the employee's date of hire. That ranges between 3 and 12. The initial measurement period, again, must apply uniformly to all new employees in the same employment classifications. We have the same 4 permissible classifications that we did with our ongoing employees. And then after we do that, we will determine whether the new employee has averaged 30 hours or more per week during our measurement period. And if so, they must be offered coverage during the employer-selected stability period that is at least as long as your measurement period. Also, with your new employees, you may include an administrative period, but the initial measurement period and administrative period combined cannot extend beyond 1 year and 1 month of the date of the employee's hire. They want you to get them on your group health plan sooner than that if they are entitled to coverage. And just like with our ongoing employee, we think the best way to sort of illustrate the points here is to give you an example. So again, we're back at Big Corp, and for new employees, Big Corp has selected the following measurement stability periods. We have an initial measurement period of 12 months from the date of the employee's hire, and the stability period is 12 months of coverage beginning on the first of the second calendar month on or after the employee's date of hire. Our administrative period in this scenario is going to be limited to 1 month. So year 1, we have employee Tina, who's a new hire, and she's hired on June 10th, 2014. And at the time of hire, Big Corp's not sure whether she's going to work 30 hours of service per week. So they put her into the new employee calculation here, and we track her hours from June 10th, 2014 up through June 9th, 2015. Let's say she does average over 30 hours per week during that time. Based on the measurement and stability periods here, Big Corp must offer Tina coverage from August 1st, 2015 until July 31st, 2016.
So, Micah, just a quick question here. Using that example, so what happens then in year 2 for Tina?
Sure, Suzanne. What happens in year 2 for Tina is we don't have a year 2 in the example because in year 2, Tina is no longer a new employee. She becomes an ongoing employee, and we've got to revert back to our ongoing employee calculation after Tina's first year.
Another question too, Micah, would be what about those folks who are exempt or salaried, that is? So they're paid, a flat amount each week. Employers might not necessarily be tracking those hours because, again, they're paid, set amount or fixed amount.
Sure, that's a great question, and I think it's a very common one. And it actually leads us into our next slide. The IRS has approved 3 different methods of determining our salaried or exempt employees' hours of service for the purposes of these measurement period calculations. And the first method is if you're already tracking the employee's actual hours. Again, you're not paying them by the hour, but you're just tracking them for other purposes. You can use the actual hours from the payroll records. If you're not doing that, which I suspect a lot of folks aren't, and that's a fairly common thing, we have 2 options, and our first option is to use the days worked equivalency, where we credit the employee with 8 hours of service for any day that they work at least 1 hour. Now, we're not paying them for all 8 hours. We only have to pay them for as long as they actually work, but we credit them automatically with the 8 hours of service for the purpose of the look-back calculation. The other option is to use the weeks worked equivalency of 40 hours per week, any week that they work at least 1 day. So that's how you can get some numbers to plug into those calculations for your exempt or your salaried employees. But an important thing to keep in mind here is we cannot use any method that's going to substantially understate the employee's hours of service. That would be frowned upon by the IRS, and in the event of an audit, you would have some explaining to do to them. So the next question that you're going to have to ask yourself as an employer to determine your status for compliance in 2014 when the large employer mandate takes effect is, what type of coverage do I have to offer, and what type of coverage are we currently offering? The healthcare reform law has made it clear that coverage has to be affordable, it has to be of minimum value, and it has to be minimum essential coverage. Again, these are all terms of art, which we'll break out here in a minute and help you to begin learning the new language that our government has provided us with. The first provision is that coverage must be affordable. So what does that mean? The IRS has indicated that coverage is affordable if the employee's contribution for self-only coverage is less than or equal to 9.5% of his or her household income. Dependent coverage is not included in the affordability calculation. But you can see there's a bit of a question that's being begged here. How do we know an employee's household income? What if our employee is married to a spouse that works somewhere other than our company? How much is she earning? How much is he earning? The IRS has recognized that could be a potential headache and a potential intrusion on our employees' privacy. So they have provided us with some affordability safe harbors, the first of which is the W-2 method. Under this method, what we do is we take a look at our employees' Box 1 W-2 wages, and then we take a look at their contribution toward their health coverage for their premium contribution. And we determine if the premium contribution is less than 9.5% of the Box 1 W-2 wages. If it is, then we can rest assured that we offer affordable coverage to that employee. The next is the rate of pay safe harbor. This only applies to hourly employees, so we cannot use this with our exempt employees. We can't do the hours worked equivalency with them here. This is only for our hourly employees. And basically what we do here is we multiply the hourly rate of pay by 130 to determine our monthly wage. Once we get our monthly wage, we determine whether the employee's monthly contributions to the cost of health insurance are less than 9.5% of that monthly wage. Again, if so, we have affordable coverage. And the final factor is determining the federal poverty level safe harbor. I can't envision a scenario where many people would opt to use this safe harbor method. Basically, it asks you to determine whether your cost of coverage is, or the employee's cost of coverage is less than 9.5% of the federal poverty level for a single individual. The federal poverty level for a single individual is relatively low. Here we have the 2012 number, which is $11,170. I believe the 2013 number is somewhere on the order of $11,420. So if you can use either the W-2 safe harbor method or the rate of pay safe harbor if you're concerned with the affordability of your plans.
And just a question for you, Micah. As employers look at making any plan design changes to their benefit plans for health insurance specifically, do you have any recommendations that you can provide or any guidance there? For example, if an employer, in an effort to try to reduce costs or maybe shift more of the cost share structure to the employee, I would suspect that could potentially alter that 9.5%. Easily.
It easily could, Suzanne, and it's absolutely something that needs to be monitored. Again, this goes back to our earlier discussion about how approaching compliance with healthcare reform is really a team effort. And in order to accomplish that compliance goal, we strongly recommend that you are in close and constant contact with your health insurance provider or your third-party administrator, especially in the event that you're considering making changes to your health insurance plan. Again, we want to be sure that we're always in compliance because in the event that we're not, Of course, we're talking about a penalty situation, which we'll get into in further detail here in a minute. So the next new phrase that healthcare reform has provided us with is that our coverage must be of minimum value. What healthcare reform has defined as minimum value is that your health plan must cover at least 60% of the total allowed costs of benefits to the plan with respect to 4 core benefits. The 4 core benefits are physician and mid-level practitioner services, so that's your family doctors and your specialists, your hospital and emergency services, pharmacy and prescription services, and then your laboratory and imaging services. Now, a lot of folks are wondering how we know if our plan meets this standard. First of all, this information should be contained in your summary plan description. The second place that you can look for the information is also in your summary of benefits and coverage. That will provide the percentage level of costs that the plan will cover for these 4 core benefits. If it does not, then again, you've got to contact your health insurance carrier or your third-party administrator, because you've got to make some changes to these documents to make sure that this information is contained there. The other thing that has been giving folks a bit of peace of mind is the fact that most health insurance carriers out there are providing plans that meet this standard. They're aware, and they don't want to sell you bad products, because then you can come back at them in the event that they sold you something that doesn't comply with law. So again, it's a teamwork approach. There are also some tools that are out there and available to determine whether your plan offers coverage of minimum value. And the first is the minimum value calculator, which I believe is developed or has been developed by the Department of Health and Human Services and the IRS, to the extent that it has not just a periodic Google search for the minimum value calculator will certainly keep you apprised as to when that will become available. There are also some design-based checklists, which the IRS is supposed to provide. I don't believe they have provided those just yet. And the final method is certification by an actuary. Again, though, this is something that you should work with your health insurance carrier or your third-party administrator, because a lot of them, from our experience, have been willing to undertake this task on behalf of their customers and clients. Our final requirement for health insurance coverage is that our coverage has to be minimum essential coverage. And we finally have gotten to a term that even the IRS had difficulty defining. All the guidance that has been issued to this point suggests that it's actually much easier to define what is not minimum essential coverage. So any medical coverage that is basically an ancillary benefit to another insurance product, such as your workers' compensation, any auto liability insurance that you have. Those sorts of things will not constitute minimum essential coverage, obviously, and it's because your employees would have to be in a work-related accident or in an accident in your car, an employer-owned car, in order to have access to that health coverage. So basically, any plan that is job-based and provides major medical benefits is pretty much going to satisfy the minimum essential coverage requirement. The fourth and perhaps most daunting question to ask yourself for compliance with healthcare reform in 2014 is, what is your company's level of exposure to penalties? There are 2 types of penalties that employers are going to have to be primarily concerned with. The first is the penalty for failure to offer coverage when you're required to do so. That's also known as the pay or play penalty. And the second penalty that could come into play for you is the penalty for failing to offer coverage that is unaffordable, and that is called the pay and play penalty. And for both of these scenarios, you're only penalized if at least one full-time employee purchases coverage through a state exchange and receives a tax credit. And you were required to offer that employee insurance coverage. So we're not penalized if our employees' dependents go out on the exchange and receive a tax credit to purchase health insurance. We're not we're not penalized if our part-time employees go out on the exchange and receive a tax credit. It's only our full-time employees, and it's only if we're required to offer them coverage. So we have to determine our employee eligibility for receipt of a tax credit. It's not necessarily a calculation they actually need to engage yourself in, but for informational purposes, if an employee is expected to have a household income of between 100 and 400% of the federal poverty level for the benefit year for which coverage is requested, and the applicants for whom the employee is expecting to claim as a personal exemption for meet the standards for eligibility for enrollment in a qualified health care plan through the exchange, then that employee is entitled to a premium tax credit or a subsidy. Again, that's not a calculation that you're going to have to concern yourself with, but these are the employees who could present a penalty problem if we are not offering them coverage or if we are offering them unaffordable coverage. And our next slide is just a brief look at the federal poverty levels for 2013. Obviously, these will be adjusted on an annual basis. So moving into the pay or play penalty, again, this is the penalty that arises when we're required to offer coverage and we do not. Under this scenario, the employer is penalized for any month that they fail to offer group health benefits to any one of its full-time employees and their dependents, and that employee or at least one of these employees goes out onto the state exchange and buys a health insurance plan upon receiving a tax credit from the government. So moving forward and calculating the pay or play penalty, the IRS has defined the penalty amount as the applicable payment amount times the number of full-time employees excluding the first 30 during the month. So the applicable payment amount for the pay or play penalty for 2014 is going to be $166.67 for any month during that year, and it's expected to rise and be adjusted for inflation for 2015. So again, moving on to an example of the pay or play penalty. In March of 2014, we're back at Big Corp, and Big Corp employs 75 full-time employees, and it does not offer anyone participation in its health insurance plan. It doesn't even offer a plan at all. One of the full-time employees goes to the state exchange and buys health coverage and receives a premium tax credit. Big Corp is now going to be penalized, and they will be penalized $7,500.15 for every month that they continue to fail to offer that coverage. Now, an important thing to note here is that, let's say Big Corp has 75 full-time employees and offers 74 of the full-time employees participation in the group health plan, and they just exclude one. If that one employee goes out on the exchange, receives a tax credit, and buys health insurance, Big Corp's penalty is going to stay the same. You're going to be penalized as if the company does not offer coverage at all, even if you just fail to offer coverage to one of your full-time employees. So we can see now how important it is to determine which employees are entitled to coverage, because if we miscalculate, we could be exposing ourselves to some pretty expensive penalties, even on top of our health insurance expenses if we're already providing coverage for most of our full-timers. The next penalty scenario is the pay and play penalty. And under this scenario, this is where we are offering coverage, but our coverage is either unaffordable, meaning it's greater than the 9.5% of an employee's Box 1 W-2 wages, or the coverage is not of minimum value, meaning that it does not cover at least 60% of the allowed costs to the plan. Under this scenario, if we have an employee a full-time employee go out on the exchange and buy health insurance upon receipt of a premium tax credit, then we will be penalized here as well. The penalty calculation for this specific penalty is different from the pay or play penalty. And if we go ahead and take a look at the calculation here, we can see that our payment amount is going to be higher. It's $250 a month times the number of full-time employees who actually receive premium tax credits after purchasing coverage on the exchange. An example of this penalty would be, again, we're back at Big Corp. We employ 75 full-time employees, and we offer health insurance, but it's unaffordable to some of them. 20 of our employees, our full-timers, go out on the exchange and they purchase coverage and they receive a premium tax credit. Now, in this scenario, our monthly penalty is going to be $250 per month times the 20 employees who actually received the tax credit to give us a $5,000 monthly penalty. Now, again, with both of these penalties, we can correct if we discover that we're either not offering coverage to everyone that we should be offering coverage to, or our coverage is unaffordable to a particular employee. We can always correct that. We don't have to wait an entire year. We don't have to incur a year's worth of penalties. So again, it's important to monitor the affordability and whether your coverage is offered to everyone who's entitled to it. The final question that you will want to ask yourself is, should we expect an increase in the cost of group health coverage? This is one of the few areas where we can provide a definitive answer in healthcare reform, and that answer is absolutely yes. It doesn't matter if you're self-insured or fully insured. We completely expect costs of group health coverage to rise. And that is a result of the health plan fees that the healthcare reform law has imposed on insurance carriers and insurance issuers. The first is the comparative effectiveness research fees. You'll often hear these referred to as PCORI. These are fees that are assessed to fund research into the effectiveness and risks and benefits of not only current healthcare but experimental healthcare options. These fees are expected to be assessed from 2012 all the way up until 2018. These are paid both by issuers, health insurance issuers, and by the self-funded plan sponsor. So if you are a self-funded insurance plan, you are paying this fee directly. And the fee for 2013 is $2 per covered life per year. So it's not just your employees, it's also their dependents. You're chipping in $2 for this fee. It will be raised potentially in 2014. It's going to be based on your plan's health expenditures. The next fee that we have is the transitional reinsurance program fees. Healthcare reform is requiring all individuals to purchase coverage, and that means all of the millions of folks out there who currently don't have coverage need to buy it. In order to subsidize some of that cost of insuring this rather large population of currently uninsured folks, we have the transitional reinsurance program fee. This fee will be assessed from 2014 through 2016. And again, it's assessed against insured and self-funded plans, and it'll be either paid by your insurance carrier if you're fully funded, or it will be paid directly by you if you're a self-funded plan. This fee is $63 per covered life per year. So again, that's all of your employees and their dependents who participate in the plan. And then finally, the health insurance tax. This plan it begins in 2014, and it is paid only by insurance carriers. It's based upon a specific carrier's market share, and it is expected to raise $1.8 billion in its first year, and then on up to, I believe, somewhere in the neighborhood of $8 billion when the tax is fully implemented. The reason that is important for us to know as employers is The health insurance companies are not going to absorb this cost out of the goodness of their heart. They're going to pass this cost on to you. So your group health plans are going to get more expensive, regardless of whether you're self-insured or you're fully funded.
Thanks, Reed. Once again, I just want to thank Micah for providing this timely information to everyone this afternoon. We do have some questions that have come through, and thanks again for everyone's patience with us. First of all, the first question is, I thought that Pennsylvania did not have a state exchange. Micah, can you comment on that for us?
I absolutely can. And again, thank you, Suzanne and Reed and McKonly Asbury as well for providing us this opportunity to present on the topic. With respect to the state exchange, every individual state is going to have its own exchange. Pennsylvania's, however, will be facilitated by the federal government. Back in December of 2012, Governor Corbett indicated that Pennsylvania is not going to administer its own exchange, so therefore the federal government is going to have to set up the exchange and administer it here in Pennsylvania. There are 25 other states that are joining Pennsylvania in not administering their own exchange, and that has actually created some delay for the federal government in fully implementing healthcare reform. For instance, as the presentation indicated, the notice of exchange has been delayed from March 1st of this year until at least August because of the substantial administrative burden that's been placed on the government to facilitate half of the state exchanges here in the United States.
Okay, thank you, Micah. The other question that came through is, it's an example. We hire one to two college students to work as tellers over the summer. Most times they work more than 30 hours per week in the months of May through August. Would we be required to offer them health coverage during that 4-month period?
Well, that is an excellent question, and it brings up one of the grayer areas of healthcare reform which still hasn't been completely finalized yet, and that is temporary employees. These college students obviously are being hired for a limited duration, obviously over their summer break. So what the interim guidance has suggested is that as long as your temporary employees are not employed for more than 120 calendar days during a given calendar year, then we're still going to be able to classify them as temporary. And therefore they would not be entitled to an offer of coverage. We suggest documenting that in an offer letter to the employees before they begin. Let them know that they are classified as temporary. Let them know that either to consult your employee handbook, which should contain a policy with respect to temporary employees and their ineligibility to participate in the group health plan. And you know, if your handbook doesn't mention that, again, consider revising the handbook, but also include in the letter that as a temporary employee, you're not going to be eligible to participate in the group health plan, and also confirm with that student that the offer of employment is only through the summer months, through their summer vacation, and a limited duration.
Thank you, Micah. And thank you for everybody that has been joining us so far. At this point, we have a few more questions that have come in that we're going to go ahead and stick around and answer. But if you need to sign off, we totally understand, and you will still be receiving CPE credit. So as of this point, the webinar is officially over, but we're going to stick around with Micah for a little while longer and answer a few more questions that came in.
Thanks, Reed. One of the questions that came through is, if our company just chooses to not offer coverage and pay the penalty, it may be cheaper than providing health insurance. Is this strategy acceptable?
There certainly is a lot of buzz about this strategy. We've heard this one from multiple sources. I think even doing a quick internet search will pull up a lot of discussion about this strategy. And nothing in the law or the guidance issued by the IRS or Department of Labor currently prohibits the practice. But what's important here is to remember that we cannot look at Obamacare in a vacuum. we have to consider the impact on our employment culture, our business reputation, our employee morale, if we decide that we're going to go from being a company who offers health insurance to being one who doesn't. So there are maybe not the health insurance costs that we're going to be incurring, but there may be other ancillary costs as a result of our decision to not offer coverage anymore.
That's a great point. The second question that came out was, how is the government going to know or decide which companies to audit for compliance with Obamacare?
Well, there are actually 3 agencies to date that have been tasked with auditing for compliance with healthcare reform. And currently the 3 agencies are the Department of Health and Human Services, the Department of Labor, and the IRS. The Department of Labor, as an example, currently sends letters out to businesses that are targeted for audit for other Department of Labor policies, Fair Labor Standards Act, wage and hour laws, and they have amended the letter now to include questions specifically targeted toward healthcare reform compliance. In addition, when your employees go to the state exchange and attempt to purchase coverage there, they're going to be required to fill out a pretty comprehensive application to participate in the exchange. That information will include, if they're employed, who their employer is, and it allows the government, again, to aggregate information and determine whether there is a potential compliance concern with a company given its number of employees that are purchasing coverage through the exchange based on the questionnaires.
Thanks, Micah. Another question that just came through. When would you expect costs to be available for January premiums?
I think that's going to be vary insurance carrier by insurance carrier. Again, this is a teamwork approach, as we indicated in the presentation. That is something that you should work with your insurance carrier, or if you're self-funded, your third-party administrator, to be sure that you're prepared for the increased costs that are coming down the pipeline. But again, that's going to vary by carrier as healthcare reform gets closer and closer to being fully implemented.
Thanks, Micah. Another question here. What if one of our employees chooses not to enroll in group health coverage and buys insurance from an exchange? Can we be penalized?
Well, that depends. And what that depends on is whether your coverage is, the coverage that's offered is affordable and of minimum value. If it meets both of those tests, then no, you will not be penalized. We're not penalized if an employee chooses not to participate in the coverage that's offered. The impetus or the goal of the law here is to provide choice to the individual in purchasing or acquiring health insurance. And so if we offer coverage that satisfies the mandates of Obamacare, then we're not going to be penalized if someone declines the coverage and decides to purchase another product through the exchange.
Thank you once again for joining us for this presentation produced by McKonly Asbury, Certified Public Accountants. We hope you join us and participate in our upcoming events. You can stay up to date with news and learn about our upcoming events by visiting us online at www.macpas.com. Thanks again and have a great day.